All right, I'm 11. I'm 11. We got 5 already waiting. We have 5 waiting on the stream, ready to get this insight, ready to get this value. I know a lot of you guys have been waiting for this video specifically. So if you guys are just tuning in, make sure you guys come here, drop a like on the video, and share this with 5 people as well too. If we share this all with 5 people, we'll have 25 people on this live stream. So I'll give you guys a second to go ahead and send this live out, and we'll get this call going here in the next 3 to 5 minutes. So on the call today, I'm not only going to go through truth and lending and what codes you guys are going to use specifically step by step throughout this process, but I'm going to read a case law study. So make sure you guys go through and study this case law as well too that I'm about to cover with you guys. And these are things which have been proven and backed in federal court. And they've gone through and won cases with these specific codes that I'm about to show you guys. And the way that they are articulated through case law will be able to help all of you guys well too. Once you guys get a good understanding of the information we're about to break through. So make sure yesterday's call will help a little bit with today's call because we're going to be really taking you guys back to truth and lending. I'm going to show you guys a couple different codes within truth and lending. If you guys were not plugged into yesterday's call, truth and lending was passed in 1968. And the title itself says everything, truth and lending. Someone was not being truthful while lending. And so therefore Congress put in place this act to protect consumers against these lenders from misusing individuals' credit and uninforming individuals upon the use of their credit as well too. And that's what we talked about yesterday, breaking down the call. We're going to go over that a little bit again today. And I'm going to show you guys how even in the case law, they talk about a misuse of one's credit. And then they go into another code, which we're going to break down. And I'm going to introduce you guys on today's call, but I'm going to go more in depth with it on Monday. I'm going to really break down the right of rescission to you guys on Monday. But today I'm going to introduce you guys to it. But it is something that is used in the case law, is reflected upon and from the right of rescission. So make sure you guys got your notebooks out. Make sure we share this with 5 people in which can benefit from this information. Now let's get right into it so we don't waste any more time. And one thing just coming in here, whether you're watching the recording, whether you guys are on the live with me, that I would love to see throughout the chat, throughout just all of the comment section as a whole, is one thing in which you guys are all grateful for. I want to have a channel around individuals that are grateful, grateful for the now, grateful for what is here, because in order to attract all of life's comings, we got to be grateful for where we're at now and all that we do have now. So drop things as you guys are on this channel, on the live, any recorded videos, any past videos. If you think about just something which you're grateful for, make sure you guys drop it in the comments, and let's have the largest community of individuals in which are just simply grateful. That's something that is cost free, and that's going to raise all of our vibrations to allow us all to attract things on higher levels of vibration. So let's get right into it. The first place where I want to take you guys is within congressional findings, like we did a little bit yesterday. So I'm going to break down and read the informed use of credit, which is coming here in 1601, chapter 41, all title 15, once again as well too. So Congress finds that the economic stabilization would be enhanced and that the competition of various financial institutions and other firms engaged in the extension of credit would be strengthened by the informed use of credit. So right away, they're letting us know the financial institutions, the firms, they'd be strengthened if we were informed upon the proper use of our credit. So that's why they put this subchapter in place, is to properly inform us upon the uses of our credit. What if I told you guys that before our credit is even ran, they're supposed to go over the procedures, the guidelines, our right to rescind. They're supposed to give us rescission paperwork, in which they don't give us, and which is why we're able to rescind a contract within 3 years, which is what we're going to cover on the call today. I'm going to read it within the case law. But coming here and exercise in 1601 itself alone can help you guys be able to get that any auto loan or title back on any car in which you guys have gone out and received. I've done this personally, and this is things, and this is why I know Truth in Lending is the most important, because I went through the process of rescinding, of going through the right of rescission, of exercising the FDCPA. I mean, where I seen these lenders, really back down the most is when I started exercising and breaking down Truth in Lending in the definition section within itself. And this is how I was able to get the debt fully discharged and removed from my consumer report completely. Is from exercising Truth in Lending. I used everything in the FDCPA, FCRA to get this auto loan removed from my report, which took me over a year to finally just exercise Truth in Lending and finally get it removed. And so I'm going to go over the steps and everything in which I had done, and then also the case law, that I'm going to cover today with the name of it, so you guys all can look up, is Jesenowski, Jesinoski, versus Countrywide Home Loan. So this is what the mortgage loan, they rescinded their whole contract, in their mortgage loan, and they were able to, win this case in the Supreme Court of the United States. So we'll go over that one here real soon. Make sure everybody is dropping questions. Make sure you guys are all, communicating. And, if you guys aren't interested in anything, drop it in the chat box. But those just streaming in, I see about 15 more people just streamed in. Make sure you guys are dropping something that you guys are all grateful for. That's why this channel is going up on a daily basis, is because we have a community of individuals in which are just grateful. Every day I practice just gratitude, things in which I'm grateful for. And that's how I've attracted every single one of you guys on this channel to this information. So continue operating in such frequency and gratitude and love, and you'll attract nothing but such. Grateful for God, life, and my kids. Amanda Sprague. I love it. I love it, Amanda, as you should be. And I love how at the beginning, first thing you were grateful for is God, because without such, life and my kids wouldn't even be a thing. So I love that. I love that, Amanda. I see my guy, Corruptions of People. Sovereign, what's good, brother? What's good, family? Where are you tuning in from? Where is everybody tuning in from as a whole? Where is most of the community based out of? Drop your city, represent where you guys are tuning in from. Let's see where everybody's at right now. Currently, I'm in Canada. I've been out here the past month, and I've been traveling, seeing a lot of Canada. It has been beautiful to see. We got Zeppelin, North Carolina. We got Pennsylvania, Placer County, California. Grateful this channel found me 100%. It's all, once again, levels of vibration. Represent Canton, Ohio. I love it. I was just on a phone call with somebody from Canton, Ohio as well too. And today specifically is the official launch of the memberships. I just dropped 3 levels of membership. I'm going to cover that real quick. We're going to take a quick break, a quick commercial break. The 3 memberships, I'm going to break them down to you guys as I said I would on yesterday's call. If you guys didn't watch yesterday's call, I highly advise you watch that. And a video that is really slept on, which I believe should be the most viewed video, is the affidavit of fact video. That one, if once you guys start drafting up affidavits and sending them to these corporations, it's going to help you guys tremendously. But the 3 levels, we got the Millionaires Club. The Millionaires Club, you guys are going to get everything from personal credit, and then a lot of the step-by-steps with consumer law. You guys are going to get it, step-by-steps for all 3 sub-chapters in which I cover within the channel, such as the FCRA, FDCPA, and Truth in Lending. So everything on the personal credit and consumer law side, step-by-steps. Within the Billionaires Club, we're going to get everything from consumer law. You guys will not get the remedy process within the Millionaires Club, but you will get it in the Billionaires Club. So everything on the personal credit side, consumer law side, every step-by-step. I'm going to show you guys how to use arbitration, how to read the contract and use their own contract against them by taking them through the arbitration process. Because just to file, a loan is going to cost them anywhere from 10 to 20,000 just to file and go through the arbitration process. And this isn't even including hiring any of their attorneys and the hourly rate in which I have to pay their arbitration attorney. So I'm going to show you guys within the Billionaires Club how to go through and take these corporations within arbitration, and a couple different methods on how to get remedy with consumer law and these codes in which we're using on these calls in which I've been given. And then in the mob, we're going to cover all of that, everything from personal credit, all personal credit, of course. But now I'm going to take you guys more into the business side of things, into the business aspect, into operating more as a business owner. I'm going to show you guys how to build business credit. I'm going to show you guys how to set up a trust. I'm going to show you guys, how to set up a 508c1a, and getting into more heavy information and documents, trust, irrevocable trust, setting up nonprofits, etc. We're going to get into all of that information within the mob. I'm going to have a lot of other, real estate investors, owners, come on this channel as well too on the mob, and give insight within their industry and a lot of the future things in which we're going to be putting together for all of YBC as a whole. So I'm excited to drop all 3 memberships within the mob as well. So you guys will get access to one of the mentorship calls that I host weekly. And my mentorship as a whole is $2,500. You guys are getting with the mob access to a community in which people are paying thousands for $25 a month, which is definitely more than worthy. And you guys are getting access to them one time every week, in which we'll be collabing with calls with the community. So, and then on top of that, you guys will get a lot of the business credit and setting up the trust and all of that information. So the mob is really going to be more insight and more hands-on work with me. So I want to take you guys here back to the definition section in Title 15, still within Truth in Lending. So we're here at 1602, which is the definition section for Truth in Lending. So yesterday we read the term creditor, and 2 days ago we had broke down how we're the ones who are regularly extending credit. And then yesterday we had broken down to whom the debt is arising from. So we know that the debt is arising from us, because in order for there to be debt, credit has to have arose, and credit has to, have taken place. Debt comes from credit. Credit does not come from debt. And so the person to whom the debt arising from the consumer credit transaction is initially payable on the face of evidence of indebtedness, or if there is no such evidence of indebtedness by agreement. So I showed you guys yesterday how using the no evidence of indebtedness to be able to get charge-offs removed. So that's a great, thing in which you guys can use to, with these contracts, just as a whole, and proper adequate notice. And I'll go through and break down this again here in a second. But the term credit sale, even within itself, refers to any sale in which the seller is a creditor. The term includes any contract in the form of a bailment or a leasee if the bailee or leasee contracts to pay as compensation for use of a sum substantially equivalent to or in excess of the aggregate value of the property. Then I want to take you guys here to the term consumer. Then I want to tell you guys here, I did a great call breaking down the term open-end credit plan. This is one of the highest viewed videos, really understanding just the open-end credit plan as a whole. And this is term J. So coming here in 1602, J, scrolling down to J, the open-end credit plan. An open-end credit plan means a plan under which the creditor reasonably contemplates repeated transaction, which prescribe the terms of such transactions, and which provides for a finance charge which may be computed from time to time on the outstanding unpaid balance. A credit plan or open-end consumer credit plan, which is an open-end credit plan or open-end consumer credit plan within the meaning of the preceding sentence, is an open-end credit plan. So if you think about something that's open-ended, there is no end to it. It's an infinite credit plan. And Congress is defining this way after they define the term credit, because in order for there to be an open-end credit plan, there's first got to be credit in the first place. They define the term person because before the term credit as a whole. So coming here, scrolling back up to the top of the definitions, notice how the term person is defined way before the term credit, because in order for there to be credit, it's got to come from a natural person. So credit comes from, once again, us. And this backs and dates how, how I mentioned within the term creditor, it mentions is the person to whom the debt arising. So we're the person and where the debt is arising from, because we're the ones who created the credit, and then we went through the transaction with them, and they gave us back debt. All right, so how can I pay something? And this is what I talked about yesterday, and just the nonsense in which is going on. How can I owe you something in which I gave you from the first place? You guys didn't obtain it. I gave you it, and then through this agreement in which I haven't even signed, especially if it's through a credit card agreement. Now you guys, and if it's with the auto loan, and I'm going to keep it in terms of with the auto loan. So say you do go through and sign the auto loan, right? It's got to be clear and conspicuous. You weren't given proper adequate notice, right? They're supposed to clearly and conspicuously break down this information. And I'm going to show you guys this here in a second. This is also within 1602, but I wanted to bring, your attention to how the term person is defined before the term credit, and then credit. The term creditor is defined after the term credit, because in order for there to be a creditor, there's first got to be credit as well too. So after that, and they define credit and a creditor. They then define the term open-end credit plan, and right after that one, they define the term adequate notice. So this is true. This is proper adequate notice in which they must give to us, the consumer, and it means a printed notice to a cardholder. All right, we are the cardholder, and it'll tell you that on your card as well too. If you guys look at any of the cards you guys have, it'll say cardholder, and then it'll be a spot for you guys to go and autograph. Which sets forth the pertinent facts clearly and conspicuously. So when they went through the contract with you, was it clear and conspicuous? If not, that it wasn't proper adequate notice, so that a person against whom is to operate could reasonably be expected to have notice and understand its meaning. Such notice may be given to a cardholder by printing the notice on any credit card or on each periodic statement of account issued to the cardholder, or by any other means reasonably assuring to the receipt thereof by the cardholder. So just right here, this alone, which sets forth the pertinent facts clearly and conspicuously, so that the person against can reasonably be expected to have noticed and understand its meaning. How many of you guys truly understood the meaning of the 30-page agreement that you guys went through with the dealership? And drop a 1 in the chat if you clearly and conspicuously were broken down, and you understood its meaning within the contract that they broke down to you, within even just the truth and lending disclosure and the payments that you guys were making and the finance charge, and even just looking under the truth and lending disclosure when it's talking about your security and how you guys are giving security interest in this vehicle. Why would I give security in something if I didn't already obtain it in the first place? And how could I give something in which I don't have? So the contract, once you guys really read and break it down, you guys will see that we're the ones who, through the contract, is giving away all the security within the property or the vehicle. And we were deceived and misled into signing this contract. And that's why we're supposed to be given our rescission paperwork. And that's why I'm going to go over this here in a second. And then the term credit card, we know, is any card, plate, coupon book, or other credit device existing for the purpose of obtaining money, property, labor, or service on credit. So we know this is any card, your social security number, your driver's license, any card with your name in all caps on it. That's your credit card. And anytime that's ran, you've been entered into a consumer credit transaction. And anytime you've been entered into a consumer credit transaction, there's a finance charge. And that's where I'm going to take you guys here now. And that's Title 15 USC 1605. Let me see. I got something for y'all. Actually, we're gonna come here and we're gonna whiteboard. I'm gonna go get a whiteboard real quick, and we're gonna whiteboard today. 1 second. All right, we 21 deep. Let's get it. I'm gonna over deliver for y'all real quick. 21 deep. Let's get the likes up though, family. It's because of the frequencies. A person means corporation, doesn't it? Yeah, so the term person, come here to 1602. It'll tell you exactly what it says. It means a natural person or an organization. Anytime we see that word or, that's a Congress letting us know that we have power. Anytime you have the ability to choose, and that's freedom. All right, you have the option to choose, and you have the ability to act on the behalf of, yes, the natural person or an organization. So if we come here, they define the term organization as a corporation, a government. So yes, you're correct, as it is a corporation, a government, or a government subdivision or agency, trust, a state, partnership, cooperative, or association. So yes, you are correct. Corruption of the people's sovereignty. I like that name. Super clean. Respect man's request. Hit the like. The word person or persons, wherever it's used. Section 1 of 7 of this title shall be deemed to include corporations and associated, existing, unauthorized, or authorized by laws of the United States, laws of territory, cops. All right, check this out. All right. So far, we got Title 15, USC 1601, and this is the misuse of one's credit. All right, so this is the first violation. So this is one. And remember, in Title 15, USC 1640, so in 1640, 15 USC 1640, remember, for each violation within 1640, it's $1,000 within this subchapter. So within each finding that we're going to find within truth and lending, the start of it is 1601. It's $1,000 per each finding, or any actual damage is done. Any actual damage. Go read Title 15 USC 1640. So far we got one finding. Then I was going to take you guys here now after we broke down the definition section. We got a lot within the definition section as well too. The term creditor, I'm going to just go ahead and label the numbers in which they're defined. So the term creditor is letter G. So you guys can go find that under Title 15 USC 1602. Coming here using the term J as well too, breaking down our open end credit plan, and how and why they're looking to get us to making payments when we have an open end credit plan, and they know how as a trustee and to acquire the funds from the TDA, from the trust Treasury Direct account. The adequate notice. This is another one right here on K. The term credit card. This is another one, because going through, and then P. Going through and using the term credit card under exclusions within the FCRA, you guys can get that removed. Once you truly understand what your credit card is, you guys will be able to get things removed with anything removed from your consumer report, going through the definition section and finding where it talks about your credit card in the exclusion section of the FCRA. So that's not for today's call. Now I want to take you guys here after we had gone over adequate notice to a finance charge, or after I read the term credit card, because I mentioned anytime your credit card is ran, you guys are entered into a consumer credit transaction. Anytime there's a consumer credit transaction, a finance charge has arose. So that's here at Title 15 USC 1605. Right, and this is where we break down the determination of a finance charge. So I had showed you guys on multiple videos and occasions of what a truth in lending disclosure will look like. What I want everybody to stop and do is go find your agreement. Go find your agreement. And within it, I want you guys to find the truth in lending disclosure. Within that, there's going to be an APR, which is the annual percentage rate. There's going to be your finance charge, which is what I'm about to break down right now. There's going to be the amount financed. Then after the amount financed, there's going to be any down payment, it'll say, and then it'll say total payments. Or typically the total payments or the down payments is within the total payment, right? They'll try to hide the down payment within the total payments. And then they'll total up the total payments, they'll total up the interest from the APR, and that'll all be within the total payments. The amount financed, it'll say right under, it'll say the amount of credit provided to you on your behalf. This is me not even looking at anyone in my face, right? This is just me knowing it off the top from seeing these contracts so much. So if it's the credit provided to me on my behalf, right? This is from that open-end credit plan in which I'm referring to, that I refer to within Truth in Lending, in which Truth in Lending is letting us know, which we have. So now we come here to the finance charge, and now we break down what the determination of a finance charge is in 1605. And it states right here, it states the amount of the finance charge in connection with any consumer credit transaction shall be determined as the sum of all charges payable directly or indirectly by the person to whom the credit is extended, and imposed directly or indirectly by the creditor as an incident of the extension of credit. So it's the sum of all charges. It's the total amount. So I've done multiple videos breaking that down. I'm not going to go too deep into that. I want to take you guys here into the case law study. So this case law study is breaking down the right of rescission. On today's call, I'm going to just I'm going to take you guys here to Title 15. So we just found another finding, A, because they made us pay more than the finance charge. The finance charge is a lot less than the total payments, in which, we'll find on our agreement once we go look at that contract. So this is another violation. Another one I want to throw at you guys and want you guys all to look over is 1604. So this right here is the disclosure guidelines. And then I want you guys to come here to C. 1604 C, and I want you guys to read that one. That's another violation within itself. But the disclosure guidelines are things in which they must disclose to you prior to even running your guys' credit. How many of you guys were disclosed the numbers of the payments in which you guys will be making prior to getting your guys' credit ran? None of you guys. Right, these are things in which in 1604 it's breaking down to you guys. And then in 1605, after a finance charge is created, so once again, and to further back that, they must disclose these things. They don't define a finance charge, and a finance charge doesn't happen until your credit is ran, until they just break down the disclosure guidelines. So that further backs that they shouldn't be running your credit until they disclose the information, the detail of the rates in which you'll be paying on that vehicle. So that's just 1604, 1605. This is 1, 2, 3, 4, 5, 6, 7, 8, 9 findings within itself, just on this call alone. And then 1611, we know Title 15, USC 1611, and then 1640, which I wrote down right here. In 1640, I've done multiple calls breaking down Title 15, USC 1640. So any video with Truth in Lending, you guys go watch that one. But 1611 will help you guys specifically because it won't only help you guys get the down payment. And so check this out. So 1611 is criminally liable for willfully and knowing violation. So whoever willfully and knowingly gives false or inaccurate information, and they don't define that because they leave it up to us to define what's inaccurate or what's false, or fails to provide information which he is required to disclose under the provisions of this subchapter or any regulation issued thereunder. So if they don't disclose the things in which they're supposed to disclose, not only this, the next code we're going to cover, which is your right to rescind, in which they don't rescind. How many of you guys have been given your right to rescind? All right, this case law alone will help you guys. You throw this out and understand and read this and utilize it just like they did within the Supreme Court case. You guys can get this handled through mail as well too, with the codes and everything we're breaking down on this video, and then within this case law as well too. And then number 3 breaks down, otherwise, if they fail to comply with any requirement imposed under the subchapter, they shall be fined more than $5,000 or imprisoned not more than 1 year or both. So now we're talking about imprisoning them if they're not, willing to cooperate, and if they're going to continue willfully and knowingly violating federal laws and codes. So now I'm going to take you guys here to the right of rescission. I'm just going to read A today, and on Monday I'm going to really go through and break down this whole thing. And I want you guys to have gone through and studied, the case law as well too. Actually, I'm going to just read the case law today. I want y'all to come back Monday. I want to see who's hungry and who's going to come back Monday to get the full breakdown of the right of rescission, the whole code within the step. I'm going to break it down. I'm going to give you guys a letter as well too that you guys can send to the dealership and to the lender so that you guys can exercise your right to rescind. And that will be on Monday's call. And that'll be for the Billionaires Club, the letter and everything. I'm going to break down the code and everything for the public, but the letter will be for everybody in the Billionaires Club. We're going to start dropping the first video tomorrow, so make sure you guys get subscribed within one of the 3 levels. I broke down what each 3 level will entail and include. So whatever you feel will best suit and fit you guys and what you guys need done, get plugged into whatever channel is best for you guys. I made them cost affordable for anybody to come in and get access to this information. There's a glare from the window. Let's see. I'm going to show you guys real quick. So we got 1601, the misuse of one's credit. We got 1602, we define the term creditor, adequate notice, an open-end credit plan, the term credit card. Then we define the finance charge. Within A, we realize that the finance charge should be the sum of all charges. When we come here to the truth in lending disclosure, the TILA disclosure, we found out the amount financed literally covers the finance charge, and the total payments is way more than the finance charge, which the finance charge is the sum of all charges defined by Congress in 1605. Then we break down the disclosure guidelines and things that they're supposed to disclose to us in 1604 before they even run our credit, in which they don't. So that's another violation. And then 1611, for them knowingly and willfully, not complying and continuously violating our rights, we can hold them, liable for $5,000, or, they can be in prison for a year, if not more. And this is what it's saying in these codes, not what I'm telling you guys. So this is what Congress is letting us know. Now we come here, and I'm going to take you guys to the Supreme Court case, and this is Larry D. Jesenowski versus Countrywide Home Loan. So this is a mortgage company in which regular consumer went through within the Supreme Court and was successful with the right of rescission. So if you guys are looking to become successful with the right of rescission, go through and study multiple other case law studies of the right of rescission. Don't just study one case law and feel that, or watch one of my videos breaking down, the right to rescind, and feel that you guys got, all of your ammo, ready to go to war. And that's what I was talking about early on the phone call today. Like, we're going to war with these corporations, and a lot of you guys are going to war empty-handed with no ammo. You guys haven't even sent off any letters. You guys don't, or maybe you guys have sent off 1 to 2 letters and you feel, I've done everything. You sent off 1 to 2 things. You don't got much evidence. Build up the evidence. Go through the administrative process. And this is the first video I'm going to drop in the Millionaires Club, is the administrative process. Go through it properly. Get all of the evidence built up. It doesn't matter if you get everything or anything removed after the administrative process. If you did or didn't, you got them where you want them. You got responses regardless. The main thing we want is a response from these companies, because now we'll have more evidence to take them, if need be, to federal court or take them through arbitration. And this is where they will not want to go, and they'll settle a lot of times before even taking it that far. But if you guys, just because you go through the administrative process doesn't fully mean you guys are going to get everything or that account removed. You got to, fully know how to stand on all 10 toes, and reading case law will definitely help as well too, just seeing the success of others. So let's dive right into it. And if you guys are just coming in, the main thing that I ask of everybody is just to come in here and drop something that you guys are all grateful for, so we can raise the levels of vibration on this channel and attract people on that frequency as well too. And then also drop a like as well too if you guys are gaining value. If you guys are not gaining value, I always ask, drop a dislike as well too, but make sure you comment what you didn't like and what you would like to see more of, so I can provide that for you guys. But here, the truth in lending disclosure gives borrowers the right to rescind certain loans up to 3 years after the transaction is consumed. The question presented is whether a borrower exercises this right by providing written notice to his lender, or whether, so once again, it's written notice, right? So make sure to mention that. Or whether he must also file a lawsuit before the 3-year period elapses. On February 23rd, 2007, petitioners Larry and Cheryl Jesenowski refinanced the mortgage of their home by borrowing $611,000 from the respondent Countrywide Home Loans. Exactly 3 years later, on February 23rd, 2010, Jesenowski mailed responses a letter perpetrating to rescind the loan. The respondent, the Bank of America Home Loan, replied on March 12th, refusing to acknowledge the validity of the rescission. On February 24, 2011, the Jesenowskis filed a suit in federal district court seeking a declaration of rescission and damages. So they were seeking a declaration of rescission and damages. So make sure you always come with the damages as well too. What are the damages that have been done and taken? And only you, the consumer, define that. It could be mental, it could be financial, it could be marital, damage that have, caused you to get divorced, or your problems in your marriage, etc. You define, the damages that have been done. Respondents moved for judgment on the pleadings with the district court. Granted, the court concluded that the act requires a borrower seeking rescission to file a lawsuit within the 3 years of the transaction consummation. Although the Jesenowskis notified the respondent of their intention to rescind within that time, they did not file their first complaint until 4 years and 1 day after the loan's consummation. So typically it's within 3 years. They didn't file it until 4 years after. Congress passed the Truth in Lending Act as amended to help consumers avoid the uninformed use of credit. As we mentioned, and I talked about that within 1601, and to protect the consumers against inaccurate and unfair credit billing. Come on, this is 1601A. To this end, the Act grants borrowers the right to rescind a loan until midnight of the 3rd business day following the consummation of the transaction or the delivery of the disclosures required by the Act, whichever is later, by notifying the creditor in accordance with the regulations of the Federal Reserve Board of his intention to do so. So 1635, this regimen grants borrowers an unconditional right to rescind for 3 days, after which they may rescind only if the lender failed to satisfy the Act's disclosures requirements. So we're only able to rescind if they failed to disclose, our right to rescind. So typically it's within 3 days. If they don't do it within the 3 days, and if they didn't disclose, then we have longer until they do disclose our right to rescind, in which they never do. So you have unless they've told you, you have unlimited time. And I know they'll tell you within the 3-year time frame or 3-day time frame, but that's if they've notified you, in which they 99% of the time have not. This regimen grants borrowers an unconditional right, once again, to rescind for 3 days, after which they may rescind I just mentioned that. Even if the lender never makes the required disclosures, the right of rescission shall expire 3 years after the date of the consummation of the transaction or upon the sale of the property, whichever comes first. The 8th Circuit's affirmation, the present case rested upon its holding in Home Capital Inc. that unless a borrower has filed a suit with the rescission within 3 years, this extinguishes the right to rescind and bars relief. That was error. So Section 1635A explains in unequal terms how the right to rescind is to be exercised. It provides that a borrower shall have the right to rescind by notifying the creditor in accordance with the regulations of the board of his intentions to do so. The language leaves no doubt that the rescission is effected when the borrower notifies the creditor of his intention to rescind. It follows that so long as the borrower notifies within 3 years after the transaction is consummated, his rescission is timely. The statute does not also require him to sue within 3 years. Nothing in 1635F changes this conclusion. Although 1635F tells us when the right to rescind must be exercised, it says nothing about how that right is exercised. Our observation in Beach versus Owen Federal Bank, 523 U.S. 1410. This governs the life of the underlying rights is besides the point. The case concerned a borrower's attempt to rescind in the course of foreclosure proceeding initiated 6 years after the loan's consummation. We concluded only that there was no federal right to rescind defensively or otherwise after the 3-year period of 1635F has run. Not that there was no rescission until a suit is filed. Respondents do not dispute that 1635A requires only written notice of rescission. And indeed, they concede that, this is the last page right here, that they further concede that the written notices after the period, if the parties agree that the lenders failed to make the required disclosures. So since they failed to provide the required disclosures, respondents argue, however, if the parties dispute the adequacy of the disclosure and thus continued availability of the right to rescind, then written notice does not suffice. So now we come here to where and how they were able to become successful. So within here, let me take you guys here. So Section 1635G states merely that in any action in which it is determined a creditor has violated this section, in addition to the rescission, the court may award relief under Section 1640. So we broke down 1640 of this title for violations of this subchapter not relating to the right to rescind. So now they're using it without, mentioning the right to rescind because it's been after the 3 years. So respondents argue that the phrase award relief in addition, because any violation within truth in lending, you can always come after them for 1640 in any time. There's no time frame on when you can come for them for 1640 and violating any law within truth in lending as a whole. So then it states, but the fact that it can be a consequence of judicial action when 1635G is triggered is no way suggests that it can only follow from such action. The Act contemplates various situations in which the question of a lender's compliance with the Act disclosure requirements may arise in a lawsuit. For example, a lender's foreclosure action in which the borrower raises inadequate disclosure as an affirmative defense. Section 1635G makes it clear that a court may not only award rescission and thereby relief the borrower of his financial obligation to the lender, but may also grant any of the remedies available under 1640. So let me read this again. 1635G makes it clear that a court may not only award rescission and thereby relieve the borrower of his financial obligation to the lender, but may also grant any of the remedies available under 1640, including statutory damages. It has no bearing upon whether and how borrowers' rescission under 1635A may occur. Finally, respondents invoke the common law. It is true that rescission traditionally required either that rescinding party return what he received before rescission could be effective, rescission at law, or else that a court affirmatively decree rescission in equity, right? The law of remedies. It is also true that the Act disclaims the common law condition precedent to rescission at law that the borrower tender the proceeds received under the transaction Title 15 USC 1635B, but the negation of rescission at law tender requirement hardly implies that the Act codifies rescission in equity. Nothing in our jurisprudence and no tool of statutory interpretation requires that a congressional act must be construed as implementing its closest common law analogy. To extend 1635B alters the traditional process for unwinding such a unilaterally rescinded transaction. This is simply a case in which statutory law modifies common law practice. The Jesenowskis mailed respondents written notice of their intention to rescind within 3 years of their loan's consummation. And because this is all that a borrower must do in order to exercise his right to rescind under this act, the court below rated in dismissing the complaint accordingly, and we reversed the judgment of the Eighth Circuit and demand the case for further proceeding consistent with this opinion. It is so ordered. And that goes to show how powerful, family, the right of rescission is. And if that doesn't, family, it takes you guys to tune back in on Monday, and I'm going to give you guys an insight of really the power of the right of rescission. But this case law right here should go to show how powerful we are, but knowing who we are more than anything is these are all laws and codes in which every consumer can go out and enforce, whether you've got your status changed or not, whether you are a secured party creditor or not. You guys can go out and exercise these laws and these codes on the behalf of a natural person or an organization. That just goes to show how powerful we all are. So I appreciate everybody tuning in. Let's see what y'all are dropping. I love it. We got Johnny Starseed, who just tuned into Billionaires Club. Welcome, family. Welcome. I'm excited to get going. Like I said, tomorrow we're gonna drop our first, channel, our first video in the channels. So I'm gonna be coming tomorrow, giving you guys some education, some value here in Billionaires Club, and welcome to the family. The goal is to empower, enrich, and educate a billion lives. What do you do if you repo just starting, studying, but understand the basics? So this call isn't so much for repos. I will do a call for repos, as that is something that I've personally gone through and experienced. So I got a lot of insight on that, and we'll be able to help you guys. And that's what really got me to dive deep into this consumer law stuff is when they repoed my car, and that got me to dive deep into all of this and led me to where I'm at now. So I'm very grateful for it also. Understand it's not ever happening to you, but always happening for you. What you do, I'm grateful for gaining this knowledge from someone as passionate about it as yourself. Thank you for waking up those who sleep. Thank you for tuning in. I'm about to get y'all I'm about to get all of this gratitude. I'm about to make a post on the Instagram. If you guys don't already follow me on Instagram or any of the socials, at CreditGotti on all socials. So we're tuned in here. We got 21 on the YouTube live. We've been here. This live is going to help empower a lot of people. The title of it alone says everything. I'm going to drop the link down below, so make sure you guys do tune in. But I wanted to come here more than anything and show you guys, the community that we're creating here on YouTube. It's a community, of individuals, that are all vibrating on the highest frequencies, and that's gratitude and love. See what we're here. We're grateful for God, life, and my kids, Amanda. We got people tuning in from North Carolina, Places County, California, Pennsylvania. Grateful that this channel found me in Canton, Ohio. All right, we come here, we see all of the gratitude that has dropped. Peace to CreditGotti. Thank you for this. There's a glare. I'm grateful for gaining this knowledge from someone as passionate about it as yourself. Thank you for waking up those who sleep. I love all of the gratitude, and that's what we're creating here is the largest community of individuals that are just grateful in all areas of life so that we can attract everything in which we desire. Let's get it, family. All right, y'all. I appreciate y'all. Johnny Starseed, I'm looking forward to connecting with you, brother. Make sure you as well, too, Johnny, schedule a call at billionairesclub.com/all. Make sure to put your YouTube name, Johnny Starseed, so I know who it is going into the call. And I look forward to connecting with you, even on a 15-minute high-level conversation call, and just within the Billionaires Club community as a whole. So I'm looking forward to it, and I appreciate everybody tuning in. Definitely go back, watch this recording, watch this video, and send this out if this helped you guys to 5 people so it can help them as well too. Peace and love. We out.